On June 23rd, the Supreme Court, in a 5-4 decision in Kelo v. City of New London, held that, I quote, economic development, close quote, can be a public use under the Fifth Amendment's takings clause. In doing so, the Supreme Court allowed the government to take perfectly fine property rights from one small homeowner and give it to a large corporation for a private business facility. As the dissent in that case pointed out, under the majority's opinion, any property may now be taken for the benefit of another private party. The government now has license to transfer property from those with fewer resources to those with more. The founders cannot have intended this perverse result. The public reaction to the Kelo decision was swift and strong. According to the Wall Street Journal and the NBC News poll, by an 11-1 margin, Americans said they opposed the taking of private property for public uses. And according to an American survey poll conducted at the time, public support for limiting the power of eminent domain is robust and cuts across demographic and partisan groups. Justice O'Connor, in a subsequent speech, called the Kelo decision scary. Even Justice John Paul Stevens, who wrote the Kelo decision for the 5-justice majority, subsequently told the Clark County, Nevada Bar Association that if he were a legislator instead of a judge, he would have opposed the results of his own ruling by working to change current law. Well, we've taken some of that advice. Well, that's exactly what the Private Property Rights Protection Act will do. This legislation has a long bipartisan history. On October 25th of 2005, then Judiciary Committee Chairman Sensenbrenner and Representative Goodlatte, current chairman, along with House Judiciary Committee ranking member Mr. Conyers, first introduced the Private Property Rights Protection Act, which would deny states or localities that abuse eminent domain all federal economic development funds for a period of 2 years. This bill was reported out of the House Judiciary Committee on October 27th by a vote of 27-3. The bill went on to pass the House with 365 votes. It subsequently passed the House by a simple voice vote. The NAACP and the AARP have said the takings that result from the Supreme Court's decision will disproportionately affect and harm the economically disadvantaged, and in particular, racial and ethnic minorities and the elderly. The representatives of religious organizations have stated that houses of worship and other religious institutions are, by their very nature, nonprofit and almost universally tax exempt. These fundamental characteristics of religious institutions render their property singularly vulnerable to being taken under the rationale approved by the Supreme Court. And the American Farm Bureau, the Federation, has stated farmers and ranchers own and lease significant amounts of land on which they depend for their livelihoods and upon which all Americans rely for food and basic necessities. As valuable as the land is to our members and to the rest of the country, however, it will often be the case that more intense development by other private individuals or entities for other private purposes would yield greater tax revenue to the local government, close quote. That's the American Farm Bureau. Congress's power to condition the use of federal funds extends to prohibiting states and localities from receiving any federal economic development funds for a specified period of time if such entities abuse their power of eminent domain, even if only state and local funds are used in that abuse of power. Such a broader penalty is an appropriate use of Congress's spending power, as the Supreme Court has made clear that Congress may attach conditions to the receipt of any federal funds, provided such conditions are related to the, quote, federal interest in particular and national projects or programs, close quote. Under this legislation, there is a clear connection between the federal funds that would be denied and the abuse Congress is intending to prevent. The policy is that states or localities that abuse their eminent domain power by using economic development as a rationale for taking should not be trusted with federal economic development funds that could contribute to similarly abusive land grabs. This legislation also includes an express private right of action to make certain that those suffering injuries from a violation of the bill will be allowed access to state or federal court to enforce its provisions. I look forward to hearing from all of the witnesses today and to continuing the bipartisan tradition here in the House of Representatives maybe even restarting it here today, and of protecting private property rights. And I would point out, as I remarked earlier, that I recall clearly the debate we had on the floor of the House of Representatives in 2005, June 30th, when we had a resolution rejecting and a resolution of disapproval of the Supreme Court's decision. And I went down to the front row and prepared myself to rebut Mr. Barney Frank of Massachusetts, because that happened often. And I took my notes on all that he said and realized that Mr. Frank and I completely agreed on this property rights Kelo decision. I'd also point out that the properties in question in New London, Connecticut are grown up to weeds. They haven't been developed, and the people that were displaced were abused by this decision and by their local government. And the very vitality of America's free enterprise economy is rooted in property rights. And without them, capital can't make wise investments, and we actually don't own our homes if it can be at the design of someone with more money and more political influence that could move eminent domain against our private property. So I'm very much in support of this legislation that's before us here today. I look forward to the witnesses, but I would